When people responsible for maintaining the safety of a parking lot don't do their job, and you're injured as a result, you can seek compensation through an insurance claim or lawsuit. In this video, we'll address one aspect of how the law determines who's liable or responsible, and then summarize your options for getting the money you need to pay for things like medical bills or lost wages. Who's to blame for a slip and fall in a parking lot? Before you can recover compensation, we need to consider who can be held responsible for your accident. The answer boils down to who is responsible for maintaining the safety of the parking lot. Let's first look at commercial parking lots. If you fall in a store's parking lot, you might think the store owner is automatically responsible, but others may actually be to blame. For example, sometimes stores will have a contract with a third-party company to do parking lot maintenance work, like plowing after a snowstorm. Other times, parking lots are not owned and operated by the store that it serves. Maybe the store exists in a shopping plaza, and someone other than the store is responsible for maintaining the parking lot, such as the owner of the shopping plaza. Slip and fall accidents happen in public lots as well. Who is responsible then? Under the New Jersey Tort Claims Act, a public entity, such as a city, can be held liable when a dangerous condition on public property causes injury to someone who is lawfully on that property. Seems clear-cut, right? Well, this act is actually somewhat complicated and subject to exceptions. Take, for example, the case of Rossi versus the Borough of Haddonfield. Mrs. Rossi sued the Borough of Haddonfield after she fractured her ankle slipping in an icy municipal parking lot. Mrs. Rossi ultimately lost her lawsuit because of what is known as the common law snow removal immunity, which basically says that under most circumstances, a public entity can't be held liable for negligent snow removal. What are your options for compensation? If you had the misfortune of being the victim of a parking lot slip and fall accident, your path to compensation may be making an insurance claim, filing a lawsuit, reaching a settlement, or going to trial. It's likely that the at-fault party has liability insurance. If they are insured, your first option will be to file a claim with their insurance company. Filing a claim amounts to accusing the insurance company's policyholder of being at fault for causing your slip and fall accident, and claiming that the insurance company is therefore responsible for paying you. If you choose to pursue the lawsuit option, your attorney will submit a document called a complaint to the court. The complaint will state that whoever you are suing is at fault for causing your slip and fall accident, and will ask the court to order them to pay you for your losses. Your attorney will then need to prove your case in court, unless the final option happens, which is to reach a settlement. You will still need to initiate either an insurance claim or a lawsuit before reaching a settlement. Essentially, a settlement is an agreement where the person or entity accused of being liable agrees to pay the person bringing the claim in exchange for the claimant or plaintiff agreeing to drop the claim. If you've been injured in a slip and fall accident, contact Rosenblum Law for a free consultation. We'll investigate who's responsible for your injuries, answer your questions, and begin the process of getting you the compensation you deserve.